Ladies and gentlemen, federal workers and injured federal workers, Riverdale Wellness proudly presents to you the Injured Federal Workers Podcast. Good afternoon, everybody, and how are we today? The Injured Federal Workers Podcast, coming to you live from the Riverdale Wellness Studios in Bronx, New York City. Good afternoon, people. Today's episode is dealing with pass, fail, approved, denied. Flip up the coin, catch it. What are we going to talk about today? Let's see. Shucks. Interesting question, right? The answer is we're going to talk about the denied stuff today, okay? Next episode, we'll talk about approved, what you got to do, all the necessary steps, but we're going to talk about denied today. Why? Unfortunately, people have denied cases, unfortunately. Whether they went to offices that didn't know what they were doing, they're looking for hope. Today's episode, we're going to take you step by step on what you need to do. We're going to bring in an experienced guest who will talk about the paperwork to file a grievance, to file for an appeal. Okay? That's today's episode. So unfortunately, we're going to deal with the denied cases. We're going to deal with what happens when your case gets denied and where do you go from there. So let's take a short break. When we come back, let's see who I bring back. All right? Thanks.
Are you suffering because you got hurt on the job? Are you struggling to find a doctor who knows how to navigate DOL and OWCP paperwork? In order to get your case to get accepted, you need a narrative from your medical doctor. When you see the doctor and they're writing a narrative report for you, the narrative report will include 1. Did you file timely? 2. Are you a federal employee? 3. What are the facts of the injury? 4. Did it happen during the performance of duties? And the last one, which is so important and crucial to your case getting accepted, it says establish. 5. Causal relationship, which means the medical evidence establishes that the diagnosed condition is causally related to the injury or event that occurred specifically to you. Please call to see if we can help you with the medical paperwork and recover from those injuries, as we have 2 decades worth of experience, and check out our Google reviews.
Hello, and we are back from commercial break, and we have a wonderful guest with us, and his name is Mr. Stephen Larkin. Good afternoon.
Good afternoon, doctor.
Okay, so where we left off was now we're up to a person having a case that's denied. They got a letter in the mail that says their case got denied. What do they do next? That's always an important question to ask. And we have with us Mr. Stephen Larkin, who is an experienced representative for injured federal workers, and he's going to tell us about the appeal request form. So I'll begin with, on the appeal request form, what is the purpose of it? Shoot, it's your turn.
Okay. All right. Hello, everybody. When cases are unfortunately denied, employees always have an opportunity to appeal the denial. This appeal is done in the form of what's called an appeal request form. The appeal request form has 3 different types of options.
All right, and we're going to blow it up now so the audience can see the appeal request form. Okay? First option over here says hearing. The second part says reconsideration. And the third part is review by the Employees' Compensation Appeals Board. And you'll explain to us now what the differences are.
Yes. First of all, the 2 types of hearings. One type of hearing simply involves sending documentation to a hearing representative who's similar to a judge. The person reviews the documentation and makes a decision based on what's sent to the hearing representative. The second option, which is one I recommend to people, is called an oral hearing. An oral hearing gives you the opportunity to present your case, to make new arguments, and to add additional documentation.
What is the difference between what's the difference between the two really, if you're appealing it, and why do you recommend the oral hearing?
Okay, as I said, with the oral hearing, you have the opportunity to make additional arguments directly to the person who's the hearing officer. So if you left something out to begin with, that may have been the reason for the denial, or if additional medical was needed, which you can have now been able to get from your doctor, that can be submitted both at the hearing and even 30 days after the hearing. Plus, the hearing officer will let you know if there's any additional information they're looking for, and will give you the opportunity to present it.
Okay, so let's just review. Review of the written record is you're just basically sending up new documentation and you don't get to speak and talk on your behalf. As opposed to the oral hearing, the purpose of the oral hearing is you speak to a judge, and if they feel that they need more medical evidence, you'll have up to 30 days basically from the time of the hearing to present it to the hearing officer.
Correct.
Are there any other benefits for going between the review of the written record or the oral hearing?
Well, as I said, if there's any information that you fail to supply the first time you present the information, you have the opportunity to explain in detail what happened, how it happened, what doctor you saw.
Basically going over the facts of the injury as
Exactly.
well as the rest of the medical record. What is the reconsideration by the district office?
Okay. When a case is denied, you've had a certain claim examiner who's been in charge of the case. When the decision comes from the claim examiner, if you do a reconsideration, it goes back to that same office, but it has to go to somebody who is not involved with the case to begin with. So they assign it to another OWCP claim supervisor, claim examiner, etc., someone who has not heard the case. That person will review any new documentation you send. And the key is you must send some type of new documentation, whether it be medical, whether it be argument. Something new has to be submitted in order to request a reconsideration.
Okay.
And to me, reconsideration and review of written record are almost identical. The only difference is you have a judge doing the review of written record, whereas you have somebody from the district office doing the reconsideration.
So for a review of written record, is it a quicker process or not really?
Well, to be honest, to get the hearing for an oral hearing takes roughly 3 to 4 months, and that decision gets made in 2 to 3 months after that. Unfortunately, you can't do anything about that aspect. If you do the review of written record and you've sent any kind of documentation, they usually will review it in about 2 to 3 months, will make a decision in 1 to 2 months afterwards. So it may save a little bit of time. However, it doesn't compensate for the fact that you get more information submitted when you do it orally. The other thing to know is either type of hearing must be requested within 30 days of the date of decision.
As opposed to?
As opposed to reconsideration, you have a year to do it from the date of decision.
Okay, so let's just focus on the form here. If you look on the form here where it says hearing, and in the next paragraph it says for each option above, you must submit this form within 30 days of the day of the decision. As opposed to reconsideration, you have to sign it basically you have to resubmit it and sign it within 1 year. So right away, you want to be punctual, audience, you want to be punctual and send it off within 30 days and fill out the hearing. What you're recommending is the oral hearing. So this way, the claims examiner can hear the case. Now, obviously, if there's medical evidence that is not ready yet, I assume you would even suggest to the audience to get it up before, so that the the hearing officer actually saw the document and has new information in front of him. So during the hearing, he can address those issues. Correct?
Correct. Not only that, sometimes when you submit new medical, the hearing officers review the information they've received after the decision letter prior to the hearing. Very often they'll say, now we've received information to prove the case. And they will simply send a preliminary hearing decision saying the case is now accepted, where you don't even have to go to present your argument.
Wonderful. So again, we're sticking to file your paperwork within 30 days, send all your medical paperwork right away, and check off for oral hearing. And this way you can represent yourself properly.
Or have somebody else represent you.
Or be represented properly, like having you, Mr. Stephen Larkin.
Now, the thing to know about the date, it's very important. The 30-day time period is from the date of decision, which is the date on top of the page. Not 30 days from when you receive it.
So that's the date over here that says April 14th, 2020, correct?
Correct.
Okay. And you can submit it all through eComp. And we've had a whole workshop on eComp on previous ones. Everything is through eComp, correct?
Correct.
Okay. Now the last one, which is review by the Employees Compensation Appeals Board, otherwise known as ECAB. What can you tell us about that?
Okay. When you have everything submitted completely and you still have a denial decision, whether it be a denial from the original denial, whether it be a denial from reconsideration, or whether it be a denial from a hearing officer, you have 180 days. That's not 6 months. It's actually 180 days exactly by a calendar. So you have to check to see what 180 days constitutes from the date of the last decision you got. Again, whether it be a hearing decision, reconsideration, or the original denial. Now, if you have everything you feel you properly can submit, then you can go to the Employee Compensation Appeal Board. You cannot submit any new evidence. You cannot submit any new medical. The only thing you can do is make argument. And again, that's 180 calendar days from the date of decision.
Okay. So I know on the second page it has the address on the paperwork. I'm not even going to say what the address is because I really want the audience to use ECAP, because you'll also get a DCN number, which is basically your proof that you submitted it. Would you agree with me?
Yes, but with the ECAP, you have to have somebody who's already set up to do it online.
Okay, that's true. And that's why at the bottom here it says ECAP Compensation Appeals Board with their address in Washington, D.C. So basically for your basic right away, filing your paperwork and all the rest, 1 and 2 can be considered, preferably 1. Get it up within 30 days and get it up through eComp.
And the thing to know also with the reconsideration, you do not have to send this form in. All you have to do is submit something new and put in writing that you're requesting reconsideration based on either new medical, new argument, or both that you're submitting.
Okay. Thank you, Steve, so very much. Can you please give everyone your contact information so they can go ahead and reach you?
Okay. Yes, my email is larkinconsultingllc@gmail.com is my email address.
Okay, and your phone number?
My phone number, 917-575-7500.
Thank you again.